But it's, again, it just tells the story of it's the evil and the ugliness of people's hearts these days is everywhere.
This is Franky Rose's Think Tank. Here's your host, Franky Rose.
Hey friends, welcome to the Think Tank. So, the letters from one entity to the other, back and forth, is what we're going to be going through today, or this evening actually. We did some of the trial for Michelle Troconis this morning. And we also did the live stream where Shanda Vander Ark was sentenced. And if you didn't see that, go back and check it out. So I've gone through these and there's a lot of repetition. Hello, Dandy. Hello, Mexi. Good to see you guys. A lot of repetition, and tell me what you guys think. We'll stop between, there's 15 pages total. We'll take little breaks and let me know your thoughts. Some of the statements are pretty bold to be putting out, I believe, and it just looks to me, again, like there's a lot of how do you put this? You know, when somebody has done something wrong and they keep going, okay, well, I didn't do it. I didn't do it. I didn't do it. That's almost what I'm feeling from these letters. We learn a bit. And like I say, there's also a fair amount of repetition, but they are worth going through. So with that said, let's do this. So this one here is from U.S. Department of Justice Joshua S. Levy to Honorable Beverly J. Canone. This was January 12, 2024, regarding the Commonwealth versus Karen Reed. Okay, so with respect to the above captioned matter, we received via letter dated January 9th, 2024 from counsel for the defendant regarding the Commonwealth's motion for protective order pertaining to the Commonwealth's notice of discovery pursuant to Mass R Criminal P 14A1EI with associated 6 attachments. We additionally received copies of the motion, the defendant's opposition, and related filings, included copies of the 8 letters at issue. We are also aware of the upcoming hearing scheduled for January 18th. We appreciate the opportunity to be heard on this issue. Having reviewed all of the materials referenced above, the Department of Justice and the U.S. Attorney's Office for the District of Massachusetts do not object to public disclosure of the correspondence at issue in the pending motion. Signed, Adam W. Deach, U.S. Attorney, Assistant U.S. Attorney. The next one is May 18th, 2023. So this one here is from Michael Morrissey, and it's going to the Office of Professional Responsibility, the U.S. Department of Justice. Now, I do believe they start to get a little ballsy. So, regarding the investigation by the Office of the United States Attorney for the District of Massachusetts, I write to formally request that an ongoing investigation being conducted by the United States Attorney's Office for the District of Massachusetts be examined by the Office of Professional Responsibility, and should the investigation continue, that it be transferred to another office without history of conflict, bias, and abuse of prosecutorial discretion is outlined below. So they're basically saying here that they're worried that there could be abuse of prosecutorial. They're saying that the Office of Professional Responsibility needs to look at this because they don't trust the Norfolk District Attorney's Office. It says it's undertaken an extensive investigation into the facts and circumstances of the death of John O'Keefe. Now, they don't say police officer John O'Keefe. They just John O'Keefe, which is very, very rare. Usually when you're talking about somebody in blue, they are officers. They are not John O'Keefe, they're Officer John O'Keefe. So why they're choosing to do this, I don't know if it's to put a different light on the situation. I don't know. So, of course, John O'Keefe passed on January 29th, 2022. The facts and evidence gathered include more than 40 individuals testifying before the Norfolk grand jury, led to the second-degree indictment of Karen Reed. Reed was the operator of the vehicle that evidence demonstrates struck her boyfriend. Oh, here we are. Police officer John O'Keefe. What evidence? O'Keefe was then left to die in the snow on the side of Fairview Road in Canton during the evening of January 29, 2022. The case has been systematically making its way through Norfolk Superior Court with ongoing discovery still active and open, including motions under advisement and motions not yet heard. The defendant, through counsel, has been raising suspicious issues of a third-party culprit and complaints of witness and police misconduct as they attempt to confuse by offering not different interpretations of Commonwealth statements, evidence, and positions, but intervening them out of violation have been identified by the defendant, the District Attorney's Office, or the Massachusetts Superior Court during the ongoing discovery process. So they're basically saying that everybody's wrong and they're right. Approximately 3 weeks ago, multiple state witnesses who have been brought before the state grand jury notified the Norfolk District Attorney's Office that there were contact by the FBI subsequently received subpoenas. So what, they all just picked up the phone and started panicking? So the subpoenas to appear before a federal grand jury. Shortly after those notifications to the Norfolk District Attorney's Office, Joshua Levy, first assistant in the Boston office of the United States Attorney's Office, contacted Norfolk First Assistant District Attorney Lynn Beland to suggest that they were conducting an investigation that involves a number of witnesses in the Commonwealth versus Reed M case. At that time, Attorney Beland expressed some concern about the jurisdiction and the timing of any actions being taken by the United States Attorney's Office, and it could be imprudent. It could imprudently impact the ongoing prosecution of Karen Reed. So they're saying what? That looking into them could impact the prosecution of Karen Reed. Isn't that interesting? Wow. In the conversation with First Assistant Norfolk District Attorney Lynn Beland, Assistant United States Attorney Joshua Levy declined to identify what jurisdiction the federal government had in this case. In what appears to be a highly unusual and possible abuse exercise of power, Attorney Levy indicated that the U.S. Attorney's Office was still proceeding ahead with the investigation that would involve individuals who were active participants in events and or witnesses in the state's case. So yeah, they're still going to look into them. Attorney Beland reminded AUSA Joshua Levy that any statements or testimony taken in such an investigation that pertain to any of the witnesses in the ongoing state M trial may create an ongoing obligation for state prosecutors to provide defense access to all information and statements gathered. What? Or recorded as a result of the federal investigation. The United States Attorney's Office offered the opinion that you can't turn over information that you don't have. This position leaves the state authorities potentially unable to meet the constitutional mandate expressed in Brady versus Maryland and corresponding Massachusetts state rules. So they're saying that they are worried that Assistant Norfolk District Attorney states Attorney Joshua Levy declined to be interviewed, and saying that they are saying that it is highly unusual and possibly abusive exercise of power by the U.S. Attorney's Office. Whoa. Huh. Now that's ballsy. That's nervy. Since that call concluded, we have confirmed that witnesses have testified before the grand jury. Rule 6 of the Federal Rules of Criminal Procedures allows that under certain compelling circumstances, information may be provided to all counsel, including those not before the federal grand jury. Recent court filings and statements by defense counsel in the Reed manner suggest that defense attorneys were the source of the initial complaint and allegations, prompting the action by the U.S. Attorney's Office. Reed's defense counsel's recent court filings raise out of thin air an apparently purposeful misstatement of fact, unsupported claims of a cover-up by investigators and witnesses, including municipal, state, and federal law enforcement, as shown in attached documents. Many of these unsupported allegations can be vetted and reviewed by the judges of Massachusetts Superior Court during the discovery motion sessions or available appellate reviews. I'm unaware and strongly doubt any prosecutor or state police misconduct in Commonwealth versus Karen Reed. The only allegations to that effect have been in unsupported news claims or defense filings that had not even been answered at the time AUSA Levy confirmed the existence of a federal grand jury. It raises the question why the apparatus of the DOJ would intervene, even as such issues are still being assessed by a justice of the Massachusetts Supreme Court, without some additional impetus or part of the United States Attorney's Office. Without dismissing the important role of the DOJ in investigating allegations of police misconduct and federal violations, we bring to your attention what appears to be additional concerns concerning motive, conflict, or appearance of conflict, and potential bias by the Office of the United States Attorney for Massachusetts. What the hell? Which might explain these unprecedented proceedings. So yeah, that's what they do. They just follow up on things that are nonsensical. They've got all the time in the world, right? Unreal. I predicate the following information with the fact that it has been the policy of the Norfolk District Attorney's Office during my 12-year tenure as district attorney to maintain a close working relationship with the United States Attorney for Massachusetts. Notable in that relationship was the cooperation of the Norfolk District Attorney's Office in the prosecution of a 35-year-old M case that was committed in Sharon, Mass., which involved Whitey Bulger, of all people. The Whitey Bulger gang in the United States versus Flemmy. The Norfolk District Attorney's Office had statutory jurisdiction to pursue the case, but in the interest of cooperation, acceded to the request of the United States Attorney at the time to allow federal prosecutors to proceed with the case. As a result of that agreement, the Norfolk District Attorney's Office and Massachusetts State Police, assigned to the Norfolk District Attorney's Office, worked closely with the U.S. Attorney's Office on the case. During this period, AUSA Dustin Chai, without a nexus to the prosecution, asked a Massachusetts State Police detective involved in the matter if he had any kind of damaging information on the district attorney, first assistant, or the Norfolk District Attorney's Office. This, okay, sponte, yeah, I'm not sure what that means. Question was not without context. Lori G. Chao, Dustin's wife, had been an employee of the Norfolk District Attorney's Office prior to the case mentioned above. Not long into her tenure, it became apparent to her supervisors that she required more seasoning and legal experience if she was to succeed in a superior court role. She was offered the chance to gain more trial experience in the district court without any loss of compensation. Instead, she resigned and filed an ethics violation complaint with the Mass Board of Bar Overseers against the First Amendment in Norfolk District Attorney's Office. The complaint before the board was summarily dismissed in short order. Laura G. Chao was instead cited for a violation of her ethical obligation to provide accurate address information for her practice. Long after separation, she was misrepresenting her address as the Norfolk DA's office. I began composing this letter well before the May 17, 2023 publication of the DOJ Office of the Inspector General Report 23-071, which has apparently prompted the resignation of the current United States Attorney of the District of Massachusetts. My attention is drawn to several portions of Section 2, particularly as they pertain to the weaponization of the U.S. Attorney Office for personal, political, and retributive purposes. We ask Rowlands whether her disclosure was retribution for the wrong she believed Hayden had committed. Additionally, we deemed the days after Hayden prevailed in the September 6th primary election, Rowlands sought to damage Hayden's reputation. Page 70. The evidence demonstrated she used her position as U.S. Attorney in an ultimately unsuccessful effort to create the impression publicly that DOJ was or would be investigating Hayden for public corruption. Oh my God, what the hell goes on? I think so. Yeah, it's not just rumor, it's not just innuendo. There's got to be something big to make them pay attention to this in any which way. Hello, Shauna. Good to see you. Good to see you. So, yeah. I mean, I don't know. Are they making a mistake going after these guys? I submit the pattern of using the USAO for personal purposes established in Report 23-071, coupled with the obvious conflict of AUSA CHAO CHA, I don't know, make it impossible to conclude that a fair evaluation of the unprecedented Reed intervention can be conducted by any party within the Massachusetts office. It is impossible to determine how far the tentacles of bias have spread out from the chief of the relevant unit to the titular head of the office. Jeez. I formally request that an impartial federal official unaffiliated with the U.S. Attorney's Office for Massachusetts review and investigate the steps and actions that are being taken by current members of the Massachusetts office, exploring this apparent bias and whether it predisposes them to abuse of their prosecutorial discretion in this matter. In the unlikely case that an impartial review finds DOJ investigation into Karen Reed matter is appropriate, even before issues at hand have been vetted by the Norfolk Superior Court judge hearing the case, I request that the investigation be reassigned from parties with clearly stated and documented biases against members of the Norfolk District Attorney's Office to attorneys entirely outside the office of the United States Attorney General for Massachusetts, Michael W. Morrissey, District Attorney for the Norfolk office. I don't know how smart that was. You're not supposed to go around pissing off the boss man. So this is the to Morrissey. The Office of Professional Responsibility, and this is June 1st, 2023. So the Office of Professional Responsibility, OPR, received your May 18th, 2023 letter requesting that OPR investigate the decision by United States Attorney's Office for the District of Massachusetts, USAO, to subpoena individuals who are witnesses in your pending state prosecution, Commonwealth versus Reed, to testify before the grand jury in an ongoing federal investigation. You stated that the USAO's investigation is possibly an abusive exercise of power and likely based only on defendant Reed's specious claims of witness and police misconduct. In addition to an investigation of the USAO's investigative decision, you requested that OPR transfer the USAO's pending investigation to another office without a history of conflict, bias, and abuse of prosecutorial discretion. OPR has jurisdiction to investigate allegations of misconduct involving Department of Justice, DOJ attorneys that relate to the exercise of their authority to investigate, litigate, or provide legal advice, as well as allegations of misconduct by law enforcement personnel that are related to allegations of attorney misconduct within the jurisdiction of OPR. However, it is the policy of this office to refrain from investigating such issues or allegations if an active investigation is going on or litigation is pending. With regard to your request that another office be assigned to the pending grand jury investigation, a matter outside the OPR's jurisdiction, OPR forwarded your complaint to the Executive Office of the United States Attorneys for whatever action it deems appropriate. Further inquiry regarding that issue can be directed to EOUSA General Counsel J. Macklin @ and gives his email address. Thank you for your concerns. Jeffrey R. Ragsdale. Unreal. So now it's going to be May 9th, Morrissey back to the Assistant United States Attorney's Office. Can you guys get over this? Hello, James. I can't. Dear First Assistant Levy, I write the following on our conversations regarding the issue of federal grand jury subpoenas to at least 2 witnesses to the Commonwealth's investigation into the death of, not police officer John O'Keefe, not Officer John O'Keefe. It's a kick. As you know, indictments have issued in Norfolk Superior Court and the prosecution is ongoing. See Commonwealth versus Karen Reed and gives the case number. As prosecuting agency, the Norfolk District Attorney's Office has the constitutional duty to provide the defendant with exculpatory evidence. The obligation in Massachusetts to provide exculpatory information pursuant to Brady versus Maryland, and so they're just saying they know of it, not that they've done it, just that they, oh, yeah, we know that. And its progeny means not only the constitutional obligation to disclose exculpatory information, but also the broad obligation under our rules to disclose any facts that would tend to exculpate the defendant or tend to diminish his or her culpability in the matter of grand jury investigation, 45 Mass. Under the Massachusetts Rules of Criminal Procedure, mandatory discovery includes all facts of an exculpatory nature and all statements of witnesses. To effectuate our discovery obligations, we are requesting at the earliest possible opportunity discovery of all statements of witness and the investigation of the death of John O'Keefe and resulting prosecution, including both statements into investigators and grand jury minutes. The Commonwealth also has the duty, at the time we become aware of statements of witnesses exist, to notify the defendant of items under Rule 14 that the prosecutor knows to exist, but are not within the care, custody, or control of the prosecution, and to provide all information known as the item's location and the identity of the persons possessing them. That's good you know all this stuff. We appreciate the sensitivity and need for discretion as to any federal investigation. While we are unaware of the perimeters of federal activity, we cannot forego our constitutional or state duties. We are willing to file a motion for a protective order under Mass R Criminal Code P 14A6 to request limitation of the disclosure of the information to defense counsel only under any decision of such request, of course. It's solely within the authority of the Norfolk Superior Court judge. Similarly, we are willing to facilitate the process or to request under Federal R. Crim P6E3 E, I, or 4. For authorization from a federal district court judge for production of grand jury minutes and related material, if any. Additionally, this office has constitutional and state obligations to provide exculpatory information of which we are aware in all cases, including exculpatory information relating to all witnesses or members of the prosecution. This would include any investigations into misconduct related to professional duties. If any such information exists, it is imperative that we learn it in a timely manner. Okay, so now they're telling them how to do things. Whoa. In sum, while we appreciate the notification that subpoenas issued, it is imperative that at the earliest opportunity, we are able to provide discovery to the defendant. Then do it. Okay. So this is June 12th. Joshua S. Levy, Acting United States Attorney, District of Massachusetts. 2. Lynn Beland, First Assistant District Attorney, Norfolk County District Attorney's Office. Dear First Assistant Beland, thank you for your letter dated May 9th, 2023. My apologies for delaying in responding, but I have been tied up with transition issues. We understand your office has important discovery obligations in any criminal prosecution. At this juncture, we have no issue with you advising defense counsel about the contact we've had with you in your office and the information we have shared if you determine such a disclosure is warranted under Mass R. Crim 14. We are mindful of all important conclusions raised in your letters and will be back in touch with you as circumstances dictate. Acting United States Attorney. So, Morrissey back to Joshua Levy, October 12th, 2023. They're just giving themselves, it's repetitive, in my opinion. And they're not making the changes necessary. So October 12th, 2023. So this is to follow up our previous communication dated May 9th, 2023, and your June 12th, 2023 response. On September 15th, 2023, the Norfolk Superior Court set a trial date of March 12th, 2024 in Commonwealth versus Karen Reed on the indictment for second-degree M and MS while operating under the influence and leaving the scene of personal injury and death. They're going to have to really show that this happened because it doesn't even come close to looking at that type of scene. Under the Massachusetts rules of criminal procedures, sorry, my voice. Give me a second. Hydrate. Okay, under Massachusetts rule of criminal procedure, mandatory discovery includes items of information within the Commonwealth's possession, custody, or control relevant to case, including statements by the defendant, Karen Reed, statements of persons who testified before the grand jury, and grand jury minutes, facts of an exculpatory manner, material and relevant police reports, photos, tangible objects, reports of physical examinations of any person, and scientific tests and experiments, and statements of persons intended to be called as witnesses, and disclosure of promises, rewards, or inducements made to witnesses the party intends to present at trial. The Commonwealth also has the duty to notify the defendant of under Rules 14A1, A1, and I think it's an 8, VIII, that are known to exist but are not within its care, custody, or control, and to provide all information known to the items located in the identity of the persons possessing that item. To effectuate our discovery obligations, we are requesting statements to investigators and grand jury minutes of witnesses in your investigation, as well as to the extent they may exist. Like, he's doing everything he can to find out what they could have. What could the feds have? Okay, any of the above described items or materials, given the impending trial date, prompt disclosure is critically important. Well, you guys aren't doing your due diligence. If there is need for limited disclosure of such items, please include such a request. We are willing, with the appropriate foundations, to file a motion. Again, their threat, file a motion for a protective order to request limitations of the disclosure of the information to defense counsel only. Any decision of such request, of course, is solely within the authority of the Norfolk Superior Court judge. Similarly, we are willing to facilitate the process or to a request under, and then they give the code, for authorization from a federal district court, federal district court judge, for production of the grand jury minutes and related material, if any, and to discuss per that rule under what conditions that material may be released for use in the state's judicial proceedings. Additionally, this office has constitutional and state obligations to provide exculpatory information of which we are aware in all cases, including exculpatory information relating to all witnesses and or members of the prosecution. This would include any investigations into misconduct related to professional entities. If any such information exists, it is an imperative that we learn of it in a timely manner. It is imperative that at the earliest opportunity, we are provided the discovery to the defendant in the investigation remains ongoing. We request notice of the status of information as to when the investigation may be concluded, in particular, whether the investigation is anticipated to conclude prior to March 2024 trial date. FBI, Boston office, November 22nd, 2023. This is from District Attorney Morrissey. Dear SAC Cohen, it was a pleasure to meet you at the State House for the governor's press conference on your hate crime enforcement. I wanted to again extend my welcome and best wishes in your role of Boston Special Agent in charge, and look forward to working with you in the future. And also wanted to renew this office's offer for your agents to speak for the state police who were involved in the John O'Keefe Canton M investigation. My first assistant district attorney also mentioned our willingness to talk to the FBI, to the acting U.S. attorney, in a recent phone conversation. If you'd like to have your investigators talk to the state police, they can contact Detective Lieutenant Brian Tully. Wow. Okay, so this is from Morrissey on June 21st, 2023. What do you guys think? It's just, it's crazy. Like, they're demanding things from a superior entity. It's blowing me away. They're demanding it. Sent by email. Read June 1, 2023, letter from OPR regarding interview of conflict of interest. Dear General Counsel Macklin, this letter is to inquire about the status of a request for a transfer of investigation due to a conflict of interest. On May 8th, 2023, the Office of the Norfolk District Attorney sent to the Department of Justice Office of Professional Responsibility a letter raising concerns as to a potential investigation by the United States Attorney's Office for District of Massachusetts involving witnesses relating to a pending state criminal matter. Commonwealth versus Karen Reed and the death of Officer John O'Keefe in Canton, Massachusetts on January 29, 2022. This office has subsequently received a June 1st, 2023 letter from Jeffrey R. Ragsdale, counsel for OPR, reflecting that to the extent that the letter indicates that the pending grand jury investigation should be reassigned, the appropriate office to address that request was the Executive Office for United States Attorney, EOUSA. This is to ensure about the status of this request and to provide contact information for any further information you may require. If you have any questions and are looking for any additional information, I may be contacted at set out above. First Assistant District Attorney Lynn Beland. So this one is from the Executive Office for United States Attorneys to Ms. Bland. This responds to your June 21st, 2023 letter concerning your punitive request for recusal of the United States Attorney's Office for the District of Massachusetts from the pending state criminal matter, Commonwealth versus Karen Reed. As you indicate, the Department of Justice Office of Professional Responsibility informed you that they had referred your May 18th, 2023 letter to my office for whatever action I deemed appropriate. Consistent with terms of the referral from OPR, I contacted Acting United States Attorney Joshua Levy. Based on my understanding from this discussion with USA Levy, his office has a very different opinion of the circumstances in this case than as presented in Mr. Morrissey's letter. His office has not reached any official determination whether prosecution is warranted, but they believe it is essential to continue their investigation given the information of which they are aware. At this time, we see no basis for recusal in this investigation. Thank you for your contact information and willingness to provide additional information. So there we go. There we go. Shut down. Absolutely shut down. Didn't the DA say that they sent these to the judge and she denied having them? Now, I'm not sure about that. I'm not sure. I don't know if I have looked at that paperwork, to be honest with you, as of yet. There is so much that I ended up finding. It blew me away. And a lot of it is gibber. It's just nobody's giving answers. They've just shut down. As far as I'm concerned, the prosecution has just shut down. They're going to do what they feel they want to do. Was it? Okay. Okay. I mean, again, it's not a good look. I don't even think, contacting them and coming out with this kind of crap and basically accused their uppers of breaking the law, basically. It's just not a good look, and it's not going to do them any favors. They were shut down. And if there's anything going on, I'm pretty sure that they're going to find out. I don't know how long until we end up finding results from the FBI's probe. Will it be before she goes to trial? I don't know. I would imagine so, right? That's not until March 12th. And they've been busy at this for some time. So I hope we hear sooner than later what they come out with. Again, I would imagine it would happen before the trial, because if this is all sideways, they're not gonna go through all of that trouble. So guys, that is what was going on with the paperwork. Those are the letters. They just sound like a bunch of ish to me. Just trying to not have to be accountable for what's possibly going on. So guys, I am going to say thank you very much for being here with me. Enjoy the rest of your evening, and I'll see you in the next one. Bye.